I'm with Dane Steffenson with the Dane Law Firm, LLC, out of Atlanta, Georgia. He and his team are leading efforts around the growing topic of misclassification in healthcare. Dane is a former senior trial attorney for the U.S. Department of Labor and a thought leader in this space. Remember, if you find this content interesting or helpful, follow our YouTube channel. Hello, Dane. Thanks for joining Other Legal News today for this interview. Thanks so much for being on.
Absolutely. Thanks for having me, Josh.
So again, this topic is pretty new, kind of interesting. I don't think a lot of people kind of know about it. Can you tell us a little bit about the misclassification right now that's going on and how it relates to the senior care industry?
Absolutely. This is not a new topic, but it's certainly maybe growing steam with the increase of the gig economy. The issue is really whether or not nurses in facilities are being classified as employees or independent contractors. Just like many other industries, this is independent contractors is a growing, it's just a growing way in which workers are being hired. The difference in the long-term care and healthcare facility space is when you're talking about nurses, you're talking about nurses who are coming into a facility that's highly regulated. We want ourselves, our family, all the patients to be cared for in very particular ways that are highly regulated by the government. So it's different to have somebody walk in and claim that they're an independent contractor into a space where we're trying to take care of vulnerable patients than other industries.
And you mentioned this is not necessarily a new issue, but it's kind of picking up steam around gig economy and stuff like that in recent years. Can you add a little color to that?
So independent contractors have existed forever. Obviously, when you hire, even if a hospital, if they're hiring a painter to come in or you're hiring a painter to come paint your house, they're not your employee. They're a true independent contractor. But what's happened is over the last 10 years or so, more and more industries have classified workers in general as independent contractors. And there's a couple different reasons for that. One side will say that it's because it saves the company or the employers a lot of money. So to employ somebody as a 1099 independent contractor, you're not providing them insurance, you're often not providing them training, you're not giving them all the employee benefits that a regular employee would get. You're not paying their FICA tax. You're not often giving them vacation pay, pension benefits, potentially not covered by workman's comp. And so for many industries, they would say you're saving at least 20+% by hiring an independent contractor over having to hire an employee. That's certainly one reason for the huge explosion of independent contractors. The other side is that there truly are a lot of people who want to work as an independent contractor. They want the independence of not being considered an employee and having to follow instructions of an employer. They want to run their own little mini business and have all that flexibility to deal with family, work schedules if they want to work. When you take this to the healthcare facility, is that really ever the case? So are those benefits actually being recognized by a nurse working in a facility? Do they get a lot of independence? Do they get to decide when to come and go? Do they get to decide how to treat a patient? No.
And beyond the financial things, is there other reasons facilities might be bringing those nurses in, or is it purely kind of financial motivated at this point in time?
There are facilities that potentially, it is possible for a facility to hire nurses from a staffing agency and not even bother to ask whether the nurse is being classified by the agency as an independent contractor or an employee. But regardless of whether they know, when they look at one agency, do I want to get a nurse from this agency or from this agency? The 1099 agency is often going to be less expensive. And again, why? The reasons I mentioned, that the agency is incurring a lot less costs, and they are providing less benefits to that to that nurse. The difference is that in terms of a risk, so the long-term care facilities, hospitals, whoever, they decide where to get the nurse from, which agency. They might go or lean towards the one that just looks less expensive on paper. At the end of the day, if they hire a nurse who has been classified as a 1099 by the agency, that agency is also never going to pay that worker overtime. Being an independent contractor, the agency will say that independent contractors are not subject to the Fair Labor Standards Act and therefore not entitled to overtime. So they allow the nurse to work over 40 hours and pay them the regular hourly rate. The staffing agency might get away with that. In other words, the staffing agency may or may not be an employer who has misclassified the worker. But in almost every instance, when a nurse walks into a facility to perform nursing work, that facility becomes that nurse's employer. And that means that that employer is going to be responsible for all those benefits that the staffing agency hasn't or isn't providing the nurse. All the benefits, but the big one being overtime. So they like that they think that it's costing them a little less. They also, many of them, without either thinking it through, or I'm not sure why they would do it, but they like the idea. Why? Let me start over. They like the idea. Facilities like the idea of being able to employ or have nurses work more than 40 hours a week, because it gives a continuity of care to patients. So a patient in the hospital is going to, all of us are going to prefer having the same nurse take care of us and not have maybe for 12 hours a day instead of 8. So we only see 2 nurses, or have that same nurse 5 days in a row instead of every day seeing a new or different nurse. So facilities like being able to have the nurses work longer hours, more than 40 in a week. The difference here is that after 40, it's difficult to imagine where nurses are not entitled to overtime. And regardless of whether the agency is responsible for the overtime, the facility is going to be.
You mentioned a little bit about the senior care facilities turning to 1099 nurses over the last few years. We all know about some of the challenges the healthcare system is seeing with COVID and other things. Was a lot of that just kind of growing out of the need for bodies during that period?
We've all seen on the news the problems that healthcare has seen during COVID, the crisis that it's been in. Every industry has had challenges trying to hire people, but potentially none has had the challenges that healthcare has faced. And so during the pandemic in particular, hospitals and long-term care facilities, if people will remember, that we couldn't even find a place to get ourselves masks. Hospitals couldn't either. And they were buying stuff from places that they had never imagined buying product from before. So their sort of desperation needs pushed them to do things they wouldn't have done in the past. And I think the same happened in this for staffing. They couldn't find enough staff. And so hospitals and facilities wound up going to agencies that they wouldn't normally have gone to. And a number of those were or became 1099 agencies. These agencies who were hiring nurses as 1099 independent contractors and then offering them to facilities. Often, I mean, the facilities are thrilled that they can get a warm body, but they can get one at a slightly less cost. I mean, seems like a win-win-win.
Absolutely. Well, let's talk about maybe the risks to the facility if worker misclassification happens. Talk a little bit about that and what that means for the facilities themselves.
As I've mentioned, when the agency doesn't provide the workers the benefits of being an employee, that's okay if the nurse is not anyone's employee. But in many instances, when you look at the independent contractor versus employee test, the nurse is going to be, they're misclassified. So meaning the staffing agency has misclassified them as an independent contractor when in legal reality, they are an employee of that staffing agency. But irregardless of whether they're an employee of that staffing agency, again, once they walk in through the doors of a facility, they're subject to a large amount of regulation that the facility is required by law to have in place. And the facility does control everything that nurse does, and we want them to. But working in that regulated facility is going to mean that that facility is that nurse's employer, and that facility is going to owe that nurse all the benefits of being an employee that the staffing agency is not providing.
You kind of mentioned earlier in your experience as a trial attorney, this is not a new issue with misclassification. From your experience and kind of your work, what have you seen penalties or liabilities that these facilities face when they're facing kind of some of this misclassification stuff?
The Department of Labor has always gone after employers, companies that they deem employers of workers that are misclassified. But in the Biden administration, it's definitely been ratcheted up a lot. And it's a top priority for the Biden administration to address misclassification of workers. And on top of that, it's been a top priority of the Biden administration to focus on low-wage workers. And then you add to that they've been focused on healthcare for a number of reasons. Maybe the biggest of which is because of the spotlight COVID has put on the healthcare industry. And you put all those factors together, it's the Biden administration is looking at low-wage workers in the healthcare industry that have been misclassified as independent contractors, and that's these nurses. And so you have a lot more cases being brought by the Department of Labor, which brings attention to the issue. And you certainly have a lot of cases continuing by private plaintiffs firms as well. So regardless of who's bringing the case, the facility is almost certainly going to be named these days as the employer, or maybe as a joint employer with the staffing agency of these nurses, and the Department of Labor or the private plaintiffs are going to be seeking back wages and other benefits from that facility. And for, at least under federal law, state law may create even more penalties, but you wind up paying your back wages ×2 because of liquidated damages. If it's a private action by private attorneys, you pay not only the 2 times back wages, but you pay all of the attorney's fees associated, which can sometimes be even larger than the back wages that are being sought. So the facility finds itself in a position where, depending on how many nurses they've hired or through these agencies, at the end of the day, they've staffed their shifts thinking they're going to pay $40 an hour to cover the work that needs to be done. And because they have hired through a staffing agency that's using 1099 nurses, they could wind up paying more than twice, maybe triple what they had planned on paying in that hourly rate. And when you, an really interesting point is that in the quote old days, which is just pre-pandemic a few years ago, excuse me, when a hospital or a facility engaged with a staffing agency, for the most part, the facility would have its own agreements and would require the staffing agency to agree to the rules that the facility wanted. Because of the shortage in the pandemic, the hospitals and facilities have been subject to agreeing to the terms of the staffing agency. And a couple of these, and one, for instance, would be Clipboard Health, has in their agreements that the facilities will actually indemnify Clipboard. So the facilities, usually you go and you bring nurses in from a staffing agency, and the facility says to the staffing agency, if you don't do what you're supposed to do correctly under the law and you cause me harm, you're going to cover my losses. Now we have agreements where the facilities are agreeing that they will indemnify the staffing agency. So in other words, Clipboard Health has 1099 nurses. They send them off to the facilities to work. The facility allows them, because Clipboard allows them, to work more than 40 hours a week. And Clipboard would essentially say, well, it's the facility's fault for letting them work over 40 hours a week if they're not, and if they're not truly an independent contractor. That's the facility's job to work out. And if Clipboard winds up owing money per Clipboard's agreement, the facility actually owes Clipboard, has to indemnify Clipboard against that loss.
Wow.
So it's a little crazy. I'm not sure that Clipboard has sued any of its clients to try and get that indemnification, but it does exist in the contract.
Wow, yeah, that's a big turn. I mean, as you talk about, that used to go the other way on things. And so if a staffing agency classifies a nurse as a 1099 IC, the facility isn't necessarily safe to rely on that agency to probably classify the nurse, it sounds like.
There are some, maybe many facilities that sort of have that thought process of, I'm conducting business these days with a staffing agency that's extremely large, and they must know what they're doing. That's the assumption at times, even from in-house lawyers. Sort of surprising that an in-house lawyer would somehow convince themselves that that's okay, but they have this thought process that if the agency must know what they're doing, they've done what they need to do to classify the worker properly, and I'm safe hiring them. Not true.
Yeah, it's a real hornet's nest there that comes through, and it's crazy that internal legal counsel would be that way, advising people that way. From your experience, is it possible for the staffing agency not the employer of the 1099 nurse, but the facility where the nurse is placed is considered his or her employer? You kind of mentioned that earlier. Is that something that could come to light here through legal action and things like that?
There definitely are cases where a staffing agency could set up its system and have so little to do with its workers that there aren't the factors that would easily make the staffing agency an employee. So the staffing agency doesn't get involved in setting the hourly rate. They let the facility do that. They don't get involved in setting the specific schedule. They don't provide any training to this worker whatsoever. As you add up those factors, it might be that a staffing agency can show that legally it is not the legal employer of that nurse. Again, once that nurse walks through the facility's doors, he or she does become the employee of that facility. And that facility is not going to be able to structure the work of a nurse in its facility the same way that a staffing agency can distance itself from that nurse as a temporary agency. So in that case, facility is going to be the employer, even though the staffing agency is not considered an employer.
So we've talked a little bit about some of these things, some of the liability, some of the training, the overtime, those types of scenarios when it comes to the nurse themselves. But are you seeing other issues arise in the last few years that are coming from this that are kind of challenging facilities and challenging the nurses themselves and how they facilitate care and how they go about this?
an agency can choose to provide, even though they call somebody an independent contractor, they could choose to provide them training and other benefits. It starts to defeat some of the purposes of trying to classify them as an independent contractor if they do that. And so in many or most cases, you're going to find that the 1099 agencies do not provide that kind of assistance to the workers. So the workers, in terms of challenges, the workers wind up not having the assistance of an employer who can provide them training, who can answer questions, who can help them navigate just things that any employee as nurses or otherwise need somebody to help them navigate. Because as an independent contractor, you're supposedly operating your own mini little business. So you're out there on an island by yourself as Nurse Jane LLC or something, and it's just you contracting to come work some hours for a facility. So they tend to have, I think they tend to have less training than W-2 nurses. And because they are sort of this independent contractor, they often are working, not always, but they're often working more diverse shifts, meaning for not consistently working as much for one facility, so that you don't have the continuity that you would have with any employee working in the same facility, understanding the systems, getting to know your coworkers, being able to get that teamwork going to provide care. So I think from both, and then the nurses' challenges come about also. We've heard nurses complain at the end of the year when they're filing their taxes. Obviously, they, to the extent they know how to take advantage of being an independent contractor, they can get some write-offs, but many of them are being hit with the Social Security tax that they didn't know that they were supposed to be paying, and being shocked. So you just wind up with a worker who's more financially strained and creating that additional stress than just the normal stress from their regular paycheck. You know, if they owe $10,000+ at the end of the year and they don't know where to get it from, it's not the best. Just they're going to be focused. They're going to be stressed, so they're going to be less focused on potentially on the patient, and certainly a little less happy of a person providing that care.
Yeah, it sounds almost like a vicious cycle. There's the upside of, hey, I can make my schedule and I can, have some time for my family and things, but you're talking about some of the other things. It seems like, do nurses even want to be 1099 independent contractors? Just the person independent, or your experience shown that there's a certain group that wants to be and a certain group that doesn't? What's your take on that?
There is certainly people in general, and I think there is a section of nurses out there that fall in the category who understand the system and choose and want to be independent contractors for various reasons. There's another large section of nurses who are looking for a job, and they sign up with a lot of different agencies, and they don't even acknowledge or understand that they just signed up for 7 agencies. 4 of them are classifying them as 1099 independent contractors, and 3 of them are going to classify them as W-2s. And then they just start looking for the shifts, and the 1099 agencies are paying 50 cents, $1, something more an hour. And so from an initial thought process, it's, why would you not want the extra $1 an hour without understanding what they're getting into? But a great many of them are just looking for work and a shift, and they're not individuals who have set up their own business and prepared to operate like a mini business.
So if you were going to give advice to nurses out there, really asking those questions, understanding as you're looking for a job, how you're being classified would be something that you would really think is important for these nurses as they kind of look for that job and sign up for these agencies.
If we talk about just the large internet-based agencies where the nurses are signing up over their phone through an app, they're signing off on lots of documents saying, yeah, and we've all done it. Like you get the little screen that just press the button that you accept the 100 paragraph terms that they just threw at you or something. And so there's a document in there that says, you understand you're an independent contractor and this is what you want to do and whatever else. And you click the button and ultimately maybe sign your name to something. And it's understandable from an efficiency standpoint why the nurses are moving through this so quickly and just trying to find their work. So I'm not even sure that how easy it is for the nurse to know upfront without spending a little bit of time understanding each time they sign up with an agency how they're being classified. And then as they work for multiple agencies, there's some real disadvantages unless the nurse purposely and wants to work for lots of different agencies and sort of control the business themselves. There's real advantages in the nurses working primarily for one or maybe two agencies instead of being so dispersed across many. And so like when they work a shift, they need to know whether that's going towards maybe earning some vacation time or whether those are hours that are going to count in the week towards hitting 40, where you might get overtime once you exceed 40. Whereas when you're just grabbing shifts from everywhere, which is sometimes done, the nurse just doesn't. One day she or he might be earning all of these other benefits while working a shift, and the next day they work another 10-hour shift, and all they're doing is getting their $20-something an hour.
Why is it difficult for nurses working in the facilities to be properly classified as 1099 independent contractors today? You've talked a little bit about it in the alluding, but I'd love to just give the audience more of a kind of a fine point on that and why that's such a challenge.
If they decide to pick up a shift with a particular agency that's a 1099 agency, then there's not a question of the nurse being able to say, do I want to be classified this way? You just are. And again, it's often the nurses deciding that they just want access to all the different opportunities of different shifts that lead them into that scenario. Yeah, it would be a different situation for sure if you could work for an agency and the nurse would choose as they sign up, do I want to be an employee? Do I want to be an independent contractor? But that never happens. There's no, and it would be really bad for the staffing agency from a legal standpoint for them to give that option. So it just out of necessity, this is how it works.
We're here with Dane Steffenson from the Dane Law LLC out of Atlanta, Georgia, talking about worker misclassification when it comes to the medical field. We're on elderlegalnews.com. If you're following this content and enjoy it, just make sure you hit the follow button and you'll be subscribed and you'll get some more of the stuff as we keep going. Dane, let's dive into one of the big questions. What about liability insurance or ongoing training when it comes to 1099 versus W-2s? What are you seeing as the difference there? Kind of who carries the liability on that or the onus to make sure that those boxes are checked?
If the nurse is a W-2 of the agency that they're being hired from, then everybody's covered. That the nurse has got proper workman's compensation, there's proper liability insurance, there's very likely fairly robust training that's provided to them. and all of the assistance that they need to succeed, because somebody is actively interacting with them as their employer to ensure that they're doing what they need to. I mean, you've got an agency who knows that they're responsible for providing talent, as opposed to a 1099 agency that often has very little to no contact with their workers. And what they're trying to do is be an Uber that merely provides a platform where workers and a facility can be matched to find each other. And so their goal as a 1099 agency is to be as hands-off as possible, to provide no training, to provide no benefits, to have nothing to really do with that worker other than providing them an electronic platform to say, hey, I'm here and I'm available, and I want to sign up for one of your shifts. And in most states, they're still going to be required, although I think there's been some questions as to whether the practice has fully been followed, but there's some things that in home care and healthcare that agencies are by law required to do, and certainly that all of us would hope or expect the agencies would do, which is to make sure that the nurse who's going to be placed in a facility has been screened and checked out at least in a minimal way. Most states require a background check. They require to know that they have CPR certification. They have to have their various vaccinations and other requirements that any employer, which includes usually an agency, has to ensure the person has. So certainly when a facility is hiring a nurse from an agency that classifies their workers as employees, that agency has done all of those things. And you know that the nurse that's coming to your facility is going to meet all of those requirements. And the company is standing behind the person and knows that they're as responsible as the individual for any mishaps that could occur. Again, to contrast with a 1099 agency who, in many instances, is going to take the position that they are not responsible. This is an independent contractor who's running their own mini business, and they're not responsible for making sure really anything about the person. If they're merely matching a facility with a worker, then it becomes the facility's obligation to ensure that that the person meets all the criteria that is required by law or that the facility would want. Again, that's in many ways defeating what was always the benefit of a staffing agency, is that this is for your temporary short-term needs. Most healthcare facilities have a percentage, 10, 20, whatever percent of workers that they use temporary staffing for, just because they have such fluctuations in bed use. It allows them to ensure they only have employed the number of nurses that are needed based on patient count. In the quote old days, the purpose of the staffing agency, though, was to find you qualified people and vet them. And so you could go and get someone who you know is qualified without you having to do that on a quick short-term basis. So I think there's an assumption in the industry that even these platform Uber type staffing agencies, there's a belief that they are still operating like the original staffing agency. And in many instances, they're not. I mean, we have a different model now.
Yeah.
So if you go to IntelliCare, ShiftMed, so, you know, a W-2 agency, you are getting that kind of service. It's the old traditional, even though they're large and they are a platform model, they provide the service that everyone is sort of used to obtaining from a staffing agency. Why we go to staffing agencies as employers. It's not necessarily the same when you go to, whether it's Clipboard, ShiftKey, Care with K, you know, they just don't necessarily do the same, anywhere near the same level of vetting, training, etc.
Seems like a real mess. Tell us a little about your firm and kind of what you guys are doing to help nurses facilities that are kind of caught up in this chaos, and kind of how that's working, what you guys are doing currently.
I started out 18 years with the U.S. Department of Labor, and I got into this field by prosecuting a lot of the facilities and some of the staffing agencies who were misclassifying or otherwise not complying with employment laws. Having done that, after 18 years, I left and went to a defense law firm and defended facilities and hospitals who were being investigated by the government. So defending basically the same thing that I used to prosecute. And after less than 2 years at that, I decided to leave and open my own firm, which is how I've wound up at Dane Law now. And so I still help facilities and hospitals if they find themselves in a position where they need to defend themselves. The hope and intent is if I am involved in that I help correct the problem so that they will come out of that with a plan on how to properly vet agencies and properly ensure that workers are classified as they should be. I also work with facilities and hospitals in advance to ensure that what they're doing is compliant with the law, which includes what staffing agencies they're using, what agreements they have in place with those agencies, what their risk factor is, to help them ensure and protect against the risk that we're talking about. And then lastly, now that I've gone out on my own, I'm able to go back to helping employees when that situation arises. So I've represented and do represent some employees against healthcare facilities where the healthcare facilities have misclassified nurses or others as independent contractors.
Well, it's good to have people out there like you that have, you know, been on both sides and understand the issue backwards and forwards. That's tremendous. And so hopefully if the facilities or nurses that are watching this and need some help, they can reach out to you guys. Let's, you know, we've kind of talked about some of the risk and some of that stuff, but, you know, why should patients care if nurses are classified as employees? Let's put a little bit of finer point on that real quick and kind of just talk through that.
As any of us are lying in a facility, hospital or long-term care facility, or we've got our parents there, it's not that an independent contractor nurse may not be an excellent caregiver. That may very well be. If I was choosing a facility up front, I would, and I have asked, where are you employing your staff from? Like, so there are certainly facilities that try and directly classify their workers as independent contractors, and I just don't think, I don't think it's a legal model, but I also just don't think at the end of the day you're going to have as happy of a workforce. And then I like to know if they're using a lot of staffing agencies, and then if the facility even knows if the people coming in are classified as employees or independent contractors. Again, there's at least a chance. Looking at percentages, employees of staffing agencies are just better trained and getting better benefits. And my preference would be that I have that type of person caring for me versus someone who likely has not received that additional training and is not being given the benefits of being an employee. Other than those few exceptions of the people who really have actively chosen to try and make that type of a classification work for them. But working in a facility and working in a hospital, even those who have chosen it, likely the law doesn't allow the employee to say, I want to be an independent contractor. The law says we have to look at the facts to decide whether you're an employee or an independent contractor. And the best indicator and the easiest cases for me is where you've got a facility that brings in nurses who are classified as 1099 independent contractors, and they're working alongside employee nurses. Can never happen. That's just not ever going to fly. You can't have independent contractors doing the exact same job that an employee is doing, and it be legal.
Thanks. I think that's going to be really helpful for our audience there. Again, going back to your experience and working for the Department of Labor, and then just your legal career, what do you see the solution being? And does the government have a role, to keep seniors safe? Kind of what's your personal opinion on this as you kind of look at it, because you've been in the space for a long time. You worked in worker misclassification prior. Tell us kind of just in your opinion, kind of in what you think the solution is here.
So the Department of Labor did not have an independent contractor rule until the end of the Trump administration. That was the first independent contractor rule, and they passed it, and was quite a mess and being challenged in the courts. And now under the Biden administration, they have attempted to issue a new independent contractor rule to replace the one Trump got through. But at the end of the day, and they are a little different, but at the end of the day, the Department of Labor has issued a new rule related to this. They've always been interested, always been focused on it, but with a new rule that will refocus energy on this issue. So that's a starting point. We should see more guidance. We do have one of the first cases I litigated with a very respectable judge in Florida put in the decision that it would be hard to imagine a scenario where a facility or a hospital is not an employer or a joint employer of nurses. And so the more cases, if that's how we have to get there, that make that statement clear, where it does seem that there are some facilities and hospitals out there still that somehow don't get the idea that it's just not, it's nearly impossible. I'm not sure how they would do it, but would be very, very difficult to properly classify a nurse in a facility or a hospital as an independent contractor. So the more that just resonates and people understand it, at least in that small portion of the workforce and small portion of the healthcare industry, that must be, for me, how that's going to get fixed in the future.
Thanks for weighing in there. Can you give some examples of some cases you're seeing brought by nurses and kind of what the facilities are being exposed to?
One really interesting case is in Pennsylvania, and it involves 16 long-term care facilities, or an organization that owns 16 different care facilities, and they are and so I don't know what the percentage is, but there's a high percentage of those workers who were brought in through clipboard health. And so they were all classified as 1099s, and the Department of Labor has sued the organization, the facilities. Not in that particular case, they haven't sued clipboard at this point. So the Department of Labor is seeking to hold the facility responsible for the misclassification of these staffing agency nurses, which, according to the numbers DOL has put out initially, is likely to be in the neighborhood of $100 million.
That's interesting to see, and I'm sure state by state, you're seeing all kinds of stuff start to crop up, as you said earlier, kind of in your opinion, more and more cases come into court, and kind of what's happening there will help kind of change some of this a little bit and bring some more clarity to the situation.
And there's just not a lot of cases out there that go the other way, meaning that support the facility or the hospital in classifying nurses specifically as independent contractors. There's certainly other people who work in hospitals who have been and likely can be classified as independent contractors. It's just the unique nurses at a minimum are in a position where they are highly regulated. They're almost always needing to work under the care of a doctor who's probably employed by that facility, and needing to follow facility instructions in how they're caring. They just don't, even though they exercise a lot of independence, it's not the level of independence that you would see from maybe a specialty doctor who runs his own practice, sees patients outside, and comes in and works with some patients and bills the patients separately for his time in that hospital. That's a much easier scenario to see how that worker who's a doctor is a independent contractor, not an employee of that hospital or facility. A nurse is not billing separately for their time. They're not running their own business and seeing patients outside of this facility. And you don't have any of those same factors.
Dane, you've given lots of good tips and advice for both nurses, facilities, and people, patients and or adult children looking. Is there any other advice you'd give to people right now that you think is really important for people to kind of keep top of mind if they're thinking about working in the industry, they run a facility, they have a loved one they're thinking about putting into a facility? Is there any other advice that you give to people out there?
If you're going to a facility, it's pretty easy to ask them if to ensure that they are using that their workers that are going to be caring for you or your loved ones are employees, and that they use staffing agencies that are employees, so that they don't think they're, quote, getting away with bringing in independent contractors. If you are a nurse who has been classified as an independent contractor and you've worked over 40 hours a week, you are almost certainly entitled to overtime. So you can reach out to me or any wage and hour attorney to discuss that case. And if you're a facility, I think that I would strongly suggest that if they are working with agencies and bringing in workers who are classified as 1099s, and the facility is not acknowledging right now that that facility is that person's employer and owes all those obligations, that facility get some legal advice on how to make a more informed decision, because that is a very risky proposition.
Well, remember, for our audience out there, you found this content helpful, interesting, subscribe to our channel. You can also go to legalnews.com. We have a couple of different ways. We have an email newsletter you can sign up for there to get notification of 1099 nurses are moving into your area. We also have a petition right now you can sign to go ahead and let leaders in your local areas know your opinion about this. Dane Steffenson from the Dane Law Firm, LLC there in Atlanta, Georgia. Dane, we really appreciate your time and your expertise. And thanks again. We might check in with you later on this year again, too, as this continues to evolve. But thank you again for your time this afternoon.
Absolutely. My pleasure to be with you. Thanks for having me. Appreciate the time.